Just grabbing my charger. Heading to Sam's for dinner.
Okay, but you'll miss your favorite tenderloin.
Wait, is that the Tuscan herb?
Mm-hmm. Hatfield marinated Tuscan herb. That's a real shame.
Did I say I was going to Sam's? Sam's coming here. Keep up, Dad.
When better care leads to better pork, it's irresistible. Hatfield Pork. Better care, better pork.
Imagine this. You're a federal judge opening your mail on an ordinary morning. But inside that envelope is a death sentence, handcrafted by a man the world had already forgotten. One explosion, one body, and a trail of clues that led investigators into a terrifying mind. A man who called himself innocent, yet knew bomb-making better than the law. This is not fiction. This is the story of Walter Leroy Moody, the man behind one of the deadliest mail bomb campaigns in American history. And what you're about to hear is how the system gave him the right to defend himself, even as he planned to kill again. You're listening to The Black Hour, true crime episodes, every Monday and Thursday. Available on Spotify and Apple Podcasts. Just search The Black Hour Show. Now let begin case. Walter Moody, the mail bomber who killed a federal judge. In 1991, an unthinkable crime sent shockwaves through the American legal system. A federal judge, Robert Vance, was murdered in his own home, not by gun or knife, but by a mail bomb. His wife, Helen, was severely injured in the blast. The man responsible? Walter Leroy Moody. A name now tied to one of the most calculated and cold-blooded attacks ever carried out against the U.S. judiciary. Moody was indicted by a Jefferson County grand jury in Alabama, charged with the capital murder of Judge Robert Vance and the felonious assault of his wife. Under Alabama law, the crime qualified as a capital offense for two reasons. 1. The murder was carried out using an explosive device. 2. It targeted a federal public official. An unprecedented attack on the justice system itself. His trial began on October 7, 1996. For nearly a month, jurors heard disturbing testimony and viewed explosive forensic evidence. On November 5th, they returned a verdict, guilty on all counts. When it came time for sentencing, the jury deliberated on Moody's fate. By a vote of 11-1, they recommended the death penalty. The judge agreed. On February 10, 1997, Walter Leroy Moody was sentenced to death for capital murder and life imprisonment for the assault on Helen Vance. At 61 years old, Moody was now the oldest person on Alabama's death row. After being sentenced to death, Walter Leroy Moody didn't give up. He began the long, complicated journey through the U.S. appeals system, determined to fight the conviction that branded him a killer. His first stop, the Alabama Court of Criminal Appeals. They reviewed his case in full, and in 2003, they affirmed both his conviction and death sentence. Moody then attempted to escalate the case further. He filed for a certiorari review, a rare legal move asking a higher court to re-examine the decision. But the Alabama Supreme Court said no, and so did the United States Supreme Court, which refused to hear his case in 2004.
Are you ready for a classic California road trip? We've got 3 amazing lodges ready to welcome you for an incredible Yosemite autumn adventure, like Evergreen Lodge, an iconic mountain resort near Yosemite's lesser-traveled Hetch Hetchy region. You'll find daily activities for all ages, with fun surprises around every corner and no hidden resort fees. Go to YosemiteHotels.com to book your fall getaway and use promo code PODCAST to get half off your third night.
Still not done, Moody shifted gears. In 2005, he filed a post-conviction relief petition in Jefferson County Circuit Court, essentially asking for a second chance. Over the next few years, he amended that petition multiple times, but in December 2009, the court shut it down, denying all relief. He appealed again,
The Alabama Court of Criminal Appeals reviewed the lower court's decision, and in 2011, they stood by it. Moody would not get another trial. Once again, the Alabama Supreme Court declined to intervene. Finally, Moody took his fight to the federal level. On December 20th, 2012, he filed a federal habeas corpus petition in the U.S. District Court for the Northern District of Alabama. His last shot at overturning the conviction. But things didn't go his way. Moody requested that the assigned judge step down from the case. The judge refused. Moody took that refusal to the 11th Circuit Court of Appeals, hoping for a writ of mandamus. But they denied it in 2014. After years of filings and arguments, the district court rejected Moody's petition entirely. Under the Anti-Terrorism and Effective Death Penalty Act, known as AEDPA, the judge found no reason to revisit the original death sentence. As the legal appeals faded one by one, the facts of the case took center stage again. Moody had reached the end of the road in the courts. His final petition for writ of certiorari, a formal request to the U.S. Supreme Court, was waiting to be reviewed. But while the law argued procedure, the crime itself was far more chilling than the paperwork. December 1989. The holiday season was in full swing across the southeastern United States. But in the quiet town of Mountain Brook, Alabama, a deadly package arrived at the home of U.S. District Judge Robert Vance. Wrapped like any ordinary parcel, it was delivered by mail. Inside, a homemade pipe bomb designed to maim and kill. When Judge Vance opened the package, it exploded in his hands. He was killed instantly. His wife, Helen Vance, stood nearby. The blast ripped through the room. Shrapnel, including nails strapped to the pipe with rubber bands, tore into her body, causing serious injuries. The device had been carefully crafted, built using a 1.5-inch steel pipe, measuring just over 5 inches long. A bomb designed not just to kill, but to send a message. Judge Vance was not the only target. That December, 4 pipe bombs were mailed to different locations across the South. The attacks were calculated, coordinated, and cruel. Forensic investigators dug into the rubble, and what they uncovered was terrifying. Someone had mailed bombs to the very heart of the American justice system. The evidence trail pointed in one direction, toward a man with a long memory, a bitter grudge, and the knowledge to build bombs from scratch. Walter Leroy Moody. The bomb that took Judge Robert Vance's life wasn't just deadly. It was engineered with purpose, with a method. It had a fingerprint, not in DNA, but in design. Investigators dissected every piece of that device. A short metal pipe, threaded end caps at both sides, packed with Hercules brand red dot smokeless powder. But it didn't stop there. Nails were strapped around the outside using rubber bands, a cruel twist meant to maximize the damage. The detonator, built from a hollowed-out ballpoint pen, simple, discreet, and devastating. The package was crafted to detonate the moment the lid was lifted. And it worked. Deadly precision. Lethal consequences. As the investigation expanded, the nightmare got bigger. That same month, December 1989, 3 more bombs surfaced across the southeastern U.S. Different cities, same style. Each device used the same Hercules smokeless powder. Each had nails affixed with rubber bands. Each used C-cell batteries in identical holders. Each was accompanied by a typed death threat note. The message was clear. This wasn't random. This was personal. There was only one key variation. Unlike the bomb that killed Judge Vance, the other 3 had welded end caps with a metal rod running through the center, locked into place by hexagonal nuts. It was sophisticated, industrial. Forensic analysts confirmed it. All 4 bombs were the work of one man. A man with rage, revenge, and resources. Even more disturbing, this wasn't the beginning. 4 months earlier, in August 1989, a strange device arrived at the NAACP office in Atlanta. Not a bomb, a tear gas canister, but it came with a message. Then the December bombs started dropping like threats from the shadows. One reached the main courthouse of the 11th Circuit. Another was intercepted at the NAACP office in Jacksonville, Florida. One more made it through,
and killed civil rights attorney Robert Robinson in Savannah, Georgia. 4 attacks, 2 deaths, 1 designer. With every box, every blast, and every silent message, one truth was becoming clearer. Walter Leroy Moody wasn't just a killer. He was a terrorist with a vendetta against justice. It wasn't just bombs that left a trail. It was the words behind them, the notes, the declarations of war. After the December 1989 explosions, media outlets began receiving typed letters. Letters filled with hatred toward the 11th Circuit, laced with threats and frustration. They weren't random rants. They were declarations of a personal vendetta. But here's what truly caught investigators' attention. These letters were typed using the same typewriter as another set of notes. Notes that came with an earlier August 1989 device. The link was forensic. The motive was deeply personal. Origins of vengeance. This war on the judiciary didn't start in 1989. It began much earlier, in 1972. That year, Walter Leroy Moody was convicted for possessing a pipe bomb. He served 3 years in federal prison, and that conviction crushed something Moody had worked for, a career in law. Before prison, Moody had attended law school and dreamed of becoming an attorney in Georgia. But a felony conviction? That dream was dead. Moody never forgave the system that stole his future. And nearly 2 decades later, he came back with a plan, not for justice, but for revenge. A web of lies. In 1985, Moody made a move straight out of a crime thriller. He wanted to erase his old conviction. Not legally, but fraudulently. He approached a woman, an acquaintance. He told her a story, a lie, about a mystery man who was supposedly the real bomber back in 1972. He bribed her. He gave her a detailed script. He and his girlfriend coached her for weeks, preparing her for court testimony. And when she was ready, Moody filed a motion to vacate his conviction in Georgia federal court, claiming he had new evidence. It was bold, elaborate, dangerous, but the court didn't buy it. Even with perjured testimony, a federal judge denied his petition. The lie failed, and from that moment forward, Walter Leroy Moody's anger turned into obsession. He had lost his case. Now, he wanted to make the system pay. The petition was dead. The 11th Circuit denied Walter Leroy Moody's last legal hope in June 1989. And shortly after that, the bomb-making began. Just a Chemical Project, summer 1989. Walter Moody and his longtime girlfriend Susan Samford began collecting materials. Moody told Susan he was working on a chemical project. At first, she believed him, but the truth would soon explode. Literally. Susan Samford helped purchase mailing labels, stamps, aluminum pie pans, nails, rubber bands and string, black latex paint, cardboard boxes and wrapping paper, C-cell batteries, flashlight bulbs, and even red dot smokeless gunpowder. Piece by piece, she was unknowingly aiding a killer. 4 bombs, 1 mission. As the summer faded into fall, Moody began constructing 4 pipe bombs. One of those bombs would soon kill federal judge Robert Vance. The others, one would fatally injure Robert Robinson, a civil rights lawyer in Georgia. Another was sent to the NAACP office in Atlanta, but safely dismantled. The 4th was mailed to the 11th Circuit Court of Appeals, same court that denied Moody's petition. The bombs were not just deadly, they were personal messages, each targeting an institution that in Moody's eyes had wronged him. Cleaning up the crime scene. Once the bombs were constructed, Moody renovated the room where he had built them. He cleaned everything, scrubbed it down, removed all trace of what had happened. According to Susan Samford, Moody was proud of his cleanup. He told her confidently, "They'll never find anything, no evidence, nothing." He believed he had built the perfect crime. Meanwhile, a federal indictment. But while Moody was busy mailing death, the federal government was circling. In July 1990, following the bombing death of Judge Vance, Moody was indicted by the United States for obstructing justice and suborning perjury, tied to his earlier attempt to fake evidence and manipulate the court. He was convicted by December 1990. But this wasn't the end. It was only the start of a complex legal journey that would last decades. By now, federal and state investigators were piecing together a terrifying realization. Walter Leroy Moody had done this before. Bombing DNA? Susan Samford told police that Moody cleaned everything so thoroughly, the only thing that could possibly tie him to the scene would be DNA. But there was more. One day, after seeing a news story about a Maryland judge hurt in a bombing, Moody casually told her, "That one wasn't me." It was the kind of statement that haunts people for life. The expert witness, an explosives expert for the state of Alabama, dropped the hammer in court. The 1972 bomb that led to Moody's original conviction, it matched in almost every technical detail the bombs from 1989. The construction, the materials, even the unique components like the battery holders and triggering systems. The expert went so far as to say the new bombs bore the signature of the 1972 bomber. In short, it had to be the same man. And if that wasn't enough, a hidden pipe. Investigators found a piece of pipe in a storage room used by Moody. It wasn't just any pipe. It had threaded end caps and resembled a transitional prototype between the two eras of bomb making. To experts, it was the missing link, a smoking gun. The right to defend himself. But Moody wasn't just a bomb maker. He had studied law, and in July 1994, 2.5 years after his indictment, Moody filed a motion in Alabama court, asking to represent himself at trial. He cited both the Alabama Constitution and federal law, referencing the U.S. Supreme Court case Ferretta versus California, the very ruling that gave defendants the right to waive counsel. A chilling statement. And then there was this. A former girlfriend of Moody's testified that he once said, "A bombing is the perfect crime, because once it goes off, there's nothing left to investigate. No fingerprints, no bullet casings, no traditional evidence. Just fire, metal, and silence." It was the summer of 1994. Over 4 years after the murder of Judge Robert Vance, Walter Leroy Moody Jr. wasn't just awaiting trial. He was preparing for battle. I have an absolute right. On July 25, 1994, Moody filed a petition in Alabama State Court. He wasn't asking for a lighter sentence or new evidence. He was demanding the right to represent himself at trial. In his motion, Moody claimed this was his absolute right. He cited Supreme Court precedent, Ferretta v. California, to back it up. This wasn't a legal novice rambling from a jail cell. This was a man who had studied the law, used the law, and now wanted to weaponize it in his own defense. Moody's confidence. In a courtroom hearing on August 2nd, 1994, Moody stood firm. He told the judge, "This is an extremely complex case, but I've been living with it for 4 years. I can dig stuff out very quickly." He argued that no one knew the case better than he did. Moody believed that only he could show the jury the truth. Not a lawyer, not a team, just him, the bomb maker turned defense attorney. The reality check. The trial judge listened, but wasn't convinced. The court made something very clear. Moody was incarcerated. Much of the key evidence was stored in Atlanta, Georgia. If he acted as his own attorney, he wouldn't be able to travel to examine that evidence. The judge stressed that proceeding without counsel could severely weaken his defense. In fact, the judge went one step further and told Moody directly, "I advise you not to do this." The strategist behind bars, but Moody wasn't looking for easy. He had already stood trial in federal court. He'd already been convicted for killing Judge Vance under federal charges. Now, in the state court, he wanted control. He wanted to build his own theory, his own defense, and deliver it his way. The courtroom was tense. Walter Leroy Moody stood before the judge, not just as a man on trial, but as a man intent on defending himself. It was a move many would later call suicidal. This is a foolhardy endeavor as Moody pressed forward with his plan to go pro se. The trial court didn't sugarcoat the risks. In fact, the judge flat out told him, "This is a foolhardy endeavor. This wasn't some petty theft case. This was capital murder, the most serious charge in the books." And if Moody lost, the only outcomes were death or life without parole. A crash course in criminal law Still, Moody insisted. So the judge gave him a crash course in criminal justice. Step by step, the court walked him through everything he'd face. Jury selection and how voir dire works. Opening statements and cross-examinations. When and how to object. And why timing could make or break a defense. The state's case in chief, followed by Moody's chance to present his own defense. And then the state's rebuttal. The court explained how summations worked and what it meant to request jury instructions. Moody was even told about the penalty phase, that second half of the trial that would decide if he lived or died. Even accomplished attorneys struggle. The judge didn't hold back. He warned Moody that even seasoned trial attorneys find capital murder trials complex and overwhelming. And yet, here was Moody, a man with no license, no legal team, and no formal access to evidence.
In Atlanta, insisting on doing it all himself. Even admitted that his lack of understanding of Alabama criminal procedure could work against him. Why did he do it? So why would a man facing the death penalty make such a high-stakes gamble? Was it arrogance? Was it control? Or was it the same cold, methodical confidence that helped him build pipe bombs, manipulate lovers, and take on the federal system for nearly 2 decades? Picture this. A man facing the death penalty, choosing to stand alone in court. No defense team. No second chances. He was warned. The judge didn't mince words. If you fail to make the right objections at the right time, you may lose your right to appeal.
Walter Leroy Moody nodded. He was warned explicitly that missteps in court could cost him his last shot at life. But Moody believed he could handle it. Why? A self-taught lawyer? Moody told the court he was 60 years old. He claimed he had a high school diploma, enough college hours for a Bachelor of Science, and 1.5 years of law school training. Not exactly Harvard law, but enough, he thought, to go toe-to-toe with the state of Alabama. No co-counsel, no backup. The judge offered him a clear choice. You can either have a lawyer or go it alone, not both. Moody chose to go it alone. He understood the risks. He knew no co-counsel would be allowed. Still, he pressed forward. The courtroom resume. Then came something that shocked even the court. The state revealed Moody's litigation history. He had been involved in 33 separate legal cases across 20 different jurisdictions. He had filed lawsuits, argued appeals, even appeared pro se by himself in 19 of them. In 7 of those, he handled the case from start to finish. Some of those filings, appeals all the way to the U.S. Supreme Court. His moment in court, during the hearing. Moody was even allowed to question the state's witness, not as a defendant, but as his own lawyer. With confidence, he reminded the judge, "You already warned me once about how important it is to know when to object." I remember. He was composed, focused, dangerous. Not because he had a gun, but because he had a mind sharp enough to bend the courtroom to his own will. Walter Leroy Moody wasn't just confident. He was obsessed with defending himself at any cost. I can win this. Standing before the court, Moody claimed something bold. He once won a case representing only himself. And after reviewing his long history of courtroom battles, the judge finally gave in. Moody was officially granted permission to go pro se, that is, defend himself without an attorney. The court released his appointed legal team, and just like that, Moody became his own defense counsel in a death penalty trial. Game on. Within hours, Moody sprang into action. He began demanding files, organizing evidence, drafting motions, and in a letter dated August 4th, 1994, he made one thing perfectly clear. I am representing myself pro se. 4 days later, another filing confirmed the same. I insist on proceeding pro se. The courtroom chess match begins. He dove deep into legal texts, filed constitutional motions, argued hearings, all on his own. 1 month later, during another hearing, the court double-checked. The judge asked, "Are you still requesting to proceed pro se?" Moody didn't hesitate. "Yes, sir." Another question. "You are not requesting the court to appoint you an attorney?" Moody replied without blinking, "That's correct." The verdict of arrogance? It wasn't bravery. It wasn't logic. It was ego. And Moody was about to find out just how deadly that kind of ego can be, in a courtroom designed to deliver justice, not mercy. The courtroom wasn't just a legal arena for Walter Leroy Moody. It was his battlefield. A new year, same fire, January 1995, Moody once again stood alone in court. No lawyer, no backup. He was still representing himself, throwing arguments directly at the judge. The hearing, a motion demanding that Moody explain why he hadn't followed a court order. But instead of backing down, Moody did what he did best. He requested more time. The court granted a continuance, pushing back the trial date once again, building a defense his way. 2 months later, March 1995, Moody returned to court, still pro se, still confident. This time, he submitted a full list of expert witnesses, just as the court had demanded earlier. Then came another curveball. Moody requested transcripts of secret ex parte hearings that had taken place when he still had a legal team. Why? Because he wasn't done digging. Not even close. I want help, but on my terms. Before ending the hearing, the judge brought up a now familiar concern. Are you still sure about representing yourself? Moody didn't flinch. He acknowledged that the court had already explained all the complexities of criminal trials back in August 1994. And yes, he still wanted to go it alone, but there was a twist. Not a lawyer, an assistant. Moody now said he wanted an attorney, but not to represent him. Not in the traditional way. Instead, he wanted someone in the background, a helper, someone who could assist him with projects, legal research, filing support, paperwork. Like a legal assistant, not a courtroom defender. One of those projects? A direct challenge to Alabama's indigent defender compensation system. An issue, by the way, that he technically had already waived. One step deeper, Moody wasn't just trying to avoid death row. He was also trying to reshape the very system prosecuting him. By now, Moody had made it clear he wasn't going to play by the system's rules unless he could bend them his way. Help me, but let me lead. March 1995, in yet another court appearance, Moody doubled down on his unusual request. I want a lawyer, but only to assist me. I'll still represent myself, ask my own questions, address the court, speak to the jury. The court pushed back. Ha! The judge reminded Moody that while, yes, he had a right to legal counsel as an indigent defendant, he did not have the right to choose who that attorney would be. Moody nodded. He understood. A crucial standoff. What followed was a telling exchange, raw, real, and full of tension. Court. This court is not going to allow you to be co-counsel. You can either represent yourself, or you'll have a lawyer. Moody, and when you say represent myself, do you mean without the assistance of counsel? Court, that's correct. Moody. But then came the twist. Moody continued, until the court shows me a counsel willing to make the sacrifices I'm willing to make, I will proceed pro se, with the understanding that I'm still asking the court to appoint someone to assist me. He wasn't backing down. Not an inch. Co-counsel? Not happening. The judge clarified it one final time. Co-counsel means you're acting as a lawyer with another attorney, both with full rights. The court would not allow that. Moody was again at a crossroads. Full control, or full representation. And he chose control. Alone in the fire, Walter Leroy Moody was preparing to take on the death penalty, without a lawyer. Just his mind, his mouth, and a mission of defiance. By this point, Moody had become a courtroom regular, not just as a defendant, but as a man battling the system on his own terms. Standby counsel. Not enough. At a March 1995 hearing, the court tried one more approach. If Moody wouldn't accept a lawyer to represent him, then maybe he'd accept standby counsel, someone to sit beside him, quietly advising, but not participating. The judge explained clearly. Standby counsel would not prepare motions, they would not investigate evidence, they would not argue before the jury. Their job? Simply to answer Moody's questions during the trial, nothing more. Moody understood, and he didn't like it. No hybrid roles. He was offered no hybrid role, no half-and-half control. The court made it clear, Moody could either represent himself, or let an attorney fully take over. And once again, Moody rejected both a year later. Fast forward to May 1996. Moody had now been representing himself for over a year and a half. Still firm in his stance, the trial court gave him another opportunity. Do you want appointed counsel to take over? But again, only if Moody agreed that the attorney would be chosen by the court, not handpicked by him. Moody declined. He had filed petitions, fought civil cases, even reclaimed an airplane in court. At the time of the hearing, he was actively representing himself in a federal appeal. Moody wasn't stumbling through the system. He was navigating it, calculating every move. The stakes, life or death. He acknowledged the charges against him, the murder of Judge Robert Vance, a capital crime. He knew exactly what that meant. The death penalty, or life in prison with no chance of parole. He also understood the additional charge, felonious assault on Judge Vance's wife, could carry 10 to 99 years, or even life. None of it rattled him. The final warning.
Still, the judge tried one last time. In court, in front of everyone, he begged Moody not to proceed without a lawyer. It is, and has continuously been, my advice that you do not proceed pro se in this case. Your choice is viewed as a foolhardy endeavor, one that could carry serious consequences. But for Moody, this was never about winning. It was about control, about narrative, about being the smartest man in the room, even when the room wanted him dead. By now, the court had tried everything to talk Walter Leroy Moody out of representing himself. And in this final round of warnings, they laid the consequences out in no uncertain terms. Your lack of legal training, the judge warned, could ultimately result in your execution in the electric chair. Moody didn't flinch. A complicated case, a lone man against the system. The judge reminded him again, capital murder trials are among the most complex and demanding in the entire legal system. Even the best defense attorneys struggle with them. And here was a 62-year-old man, alone, locked up, with no access to outside investigation tools or legal teams, determined to take it all on. Trapped before the trial begins, Moody was reminded that because he was incarcerated, he couldn't travel to visit evidence sites. He couldn't meet experts or interview witnesses. He'd be stuck preparing for a capital trial from inside a cell. And when the judge went over the full anatomy of a trial, motions, objections, jury selection, evidentiary hearings, Moody still refused to back down. I understand, Moody said. You have the right, but you don't have the ability to exercise that right. He wasn't wrong. He understood his constitutional rights, but not the practical barriers they came with. A battle of rights versus reality. In one exchange, Moody finally cracked open a deeper truth. A lot of people have explained what my rights are not as an indigent person. But no one has explained what my rights actually are. How do I file motions? How do I subpoena witnesses? I have no money. I have no assistance. So how do I exercise these so-called rights? It wasn't just a fight against the system. It was a fight against the illusion of control. The judge calmly replied, "You have the right to have an attorney appointed to you." Moody shot back, "But I also have the constitutional right to represent myself." Once again, the court offered help. And once again, Moody refused it. And one final time, the judge made it clear. He would not help Moody during the trial. Any mistake Moody made, he would own it alone. "Mr. Moody, I need to advise you again." That was the judge's voice. Tired, maybe even emotional. Because by now, it had been said dozens of times. I believe it is in your best interest to accept appointed counsel. Continuing to represent yourself when you are facing a possible death sentence is extremely unwise. But Walter Leroy Moody didn't waver. Even in August of 1996, just 2 months before trial, when the judge offered him yet another final out, Moody shut it down. "I do not want a lawyer," he said. Final review and a dead-end appeal. At this point, everything had been done. The court had gone above and beyond to give Moody every opportunity to change course. But he wouldn't, and that decision would echo in every appeal he made afterwards. The final petition to the Supreme Court. Moody's final legal maneuver was a petition for writ of certiorari, a formal request
asking the United States Supreme Court to review his case. What he wanted: for the court to revisit the historic ruling of Ferretta versus California, 1975, which gives a criminal defendant the right to represent themselves in court. Moody's team pointed to a concurring opinion by Judge Beverly Martin, who questioned whether that right, when applied in death penalty cases, might be dangerously outdated. In short, they were asking the Supreme Court to reconsider whether Ferretta was a mistake in Moody's context. But here's the problem. There were two massive issues with Moody's argument. One, he didn't exhaust his state court remedies. That means he never fully brought this argument through the right steps in Alabama's state system before jumping to the federal level. And under federal law, specifically, the Anti-Terrorism and Effective Death Penalty Act of 1996, or AEDPA, if you skip that step, your petition is dead on arrival. Two, even if he had, the court wouldn't touch it because under AEDPA, federal courts only get involved if a clear constitutional violation occurred that directly conflicts with past Supreme Court rulings. Moody's argument? It wasn't based on a violation. It was based on wanting the court to change its precedent. And the court doesn't do that lightly. Especially when the issue, the right to represent yourself, was already firmly settled in Ferretta. A flawed fight too late. Even Judge Martin, who felt emotionally conflicted, still ruled against Moody. She simply added her opinion that maybe, the law should be rethought for future defendants. But that didn't help Moody. His appeal was dead before it ever really began. And so the legal system closed the door. The judge's warnings had come true. The right to represent yourself had become the right to destroy your own future. After years of filings, hearings, motions, and back-and-forth arguments, the case of Walter Leroy Moody had reached its final stop, the United States Supreme Court. But what stood before Moody now wasn't just the law. It was a wall called the AEDPA, the Anti-Terrorism and Effective Death Penalty Act of 1996. A Supreme Court petition and why it failed. Moody's legal team had made their last play. They filed a petition for writ of certiorari, asking the highest court in the country to take up two questions. One, should the precedent set in Ferretta versus California, the right to self-representation, be reevaluated in the context of death penalty cases? Two, did the lower courts make an error in allowing Moody to represent himself? But the response from the state of Alabama? Clear, detailed, and brutal. Why the Supreme Court wouldn't even consider it. Problem number one, failure to exhaust remedies under AEDPA. A defendant must fully argue their claim through every level of the state courts before they can ask a federal court to intervene. But Moody didn't. He never challenged his waiver of counsel. Not to the Alabama Supreme Court, and not in any way that satisfied the exhaustion requirement. He even affirmatively stated, in his own filings, that he chose to waive his right to counsel. That alone was enough to kill his petition. Problem number two. Not the right case to revisit Ferretta. Judge Beverly Martin had expressed concern about Ferretta in her concurring opinion. She questioned the wisdom of letting people in capital murder trials defend themselves. But the state pointed out this wasn't the case to test that theory. Why? Because Moody never changed his mind. He never asked for a lawyer later on. He didn't request a transition or safety net. He wanted to represent himself, unless he could handpick the attorney. That's not what Ferretta says, and it's not grounds for Supreme Court review. Problem number three. The petition focused on the wrong thing instead of attacking the 11th Circuit's ruling, which affirmed the federal court's denial of relief. Moody's petition criticized the Alabama Court of Criminal Appeals' earlier ruling. But here's the thing. The Supreme Court doesn't review state court opinions directly in federal habeas cases. They only look at whether the federal appeals court, in this case, the 11th Circuit, correctly applied federal law. And Moody? He barely mentioned the 11th Circuit at all. Rule 10. And the cert denial under Supreme Court Rule 10. The court only grants certiorari when there's a conflict between different courts of appeal. A state court's decision dramatically departs from normal legal proceedings. There's a major constitutional issue at stake. Moody's petition? It checked none of those boxes. Even the state said it plainly. This was a textbook example of a petition not worthy of Supreme Court review. Conclusion: the final word. And so, the filing ended with a simple but powerful statement. For the foregoing reasons, this court should deny Moody's petition for writ of certiorari. It was signed by Alabama's top legal officers: Attorney General Steve Marshall, Solicitor General Andrew Brasher, and Deputy AG James Roy Houts. And with that, Walter Leroy Moody's long, winding legal journey was over. He was a man who built bombs, argued his own case, and fought the system to the very end. But the law never blinked. And in the end, it was not just the evidence. It was the choices he made, over and over, that sealed his fate. You've just listened to The Black Hour, where true crime meets chilling truth. If this case shook you, wait till you hear what's coming next. Don't forget to follow and rate the show on Spotify and Apple Podcasts. Just search The Black Hour. New episodes drop every Monday and Thursday. Until next time, stay safe, stay aware, and remember, sometimes the scariest monsters don't hide in shadows. They hide in plain sight. This was The Black Hour. New true crime every Monday and Thursday. Search us on Spotify or Apple Podcasts, and don't forget, the truth is always darker than it seems. And hey, if you've lived through something strange, something horrifying, send your story to the email in the description. theblackhourpodcast01@gmail.com. Who knows, the next episode might be yours. Bye guys, thanks for listening. Bye.
Are you ready for a classic California road trip? We've got 3 amazing lodges ready to welcome you for an incredible Yosemite autumn adventure, like Evergreen Lodge, an iconic mountain resort near Yosemite's lesser-traveled Hetch Hetchy region. You'll find daily activities for all ages, with fun surprises around every corner and no hidden resort fees. Go to YosemiteHotels.com to book your fall getaway and use promo code PODCAST to get half off your third night.